This is the Notice to Pay or Vacate module for your aDoor property management training. In this video, we're going to talk about all the important aspects of a 3-day notice to pay or vacate. A 3-day notice to pay or vacate is the notice by which we make a demand on the tenant who has failed to pay rent timely as required by the lease agreement, or if it happened to be a verbal agreement on the day that was agreed to. And in our lease agreement, we have the due date as the first day of the month, and that is the date that rent is owed. In general, the 3-day notice to pay or vacate is regulated by Florida Statutes 83.56, subsection 3. And it provides that if the tenant failed to pay rent, that you have to deliver a specific notice to pay or vacate that's in substantial conformity with the language that is here in the middle of this section to make that demand. And we have a form that we use, the same form every time, that we fill in particular to that tenant. Before we get into some of the details here, just pause the video and read over what are the common reasons for a defective notice. This is very important to understand because a defective notice could render an eviction defective. So we would lose an eviction if the notice is defective. So just pause the video for a moment, read the list here so you can familiarize yourself with basically courts' decisions on defective notices. Another thing that we have to keep in mind is that we cannot deliver the 3-day notice to pay or vacate before it's actually ripe for delivery. And what that effectively means is if there's a grace period or a late fee date stated in the lease agreement, we cannot deliver the notice to pay or vacate until that late fee date has expired. So let's just say, for example, that the tenant has until the 3rd day of the month or the 2nd day of the month before late fees accrue. We cannot deliver a 3-day notice before that late fee date has expired. If we do, it could be deemed to be premature. In the form itself, we have to complete the to section, that is who it's going to. By law, we have to include all of the tenants' names in this section who are on the lease agreement. So look at the lease agreement and get all the tenants' names from the lease agreement and put that into the to section. One thing to really keep in mind as well is that we have to make sure the names are spelled correctly. There are times where there's a typo on the lease agreement, or maybe there's a typo in the software program we use. So you want to make sure that the names are spelled correctly, because it can present problems in the future if we go to enforce that notice through an eviction. Under the from section, it's coming from us, the property management company, so we put our business name here in the from section. There are other issues that really don't have a lot to do with us, because when we send out a notice, we're sending out a notice from us on behalf of the landlord. But if this were a situation where a landlord is filling out this himself, they have to make sure that they're putting in the legal name that's on the title itself as being in the from section. Having an incorrect name of the landlord can also render a notice defective. Again, we make sure that the notice is ripe for delivery. We deliver the notice after the late fee date has expired. And in the premises section, we put in the full address. So we're putting in the street number, street name, a unit number if there's a unit, the city, the state, the zip code, and also the county that the property is located. As we talk about in other videos, we can only demand rent as defined by the lease agreement in the 3-day notice to pay or vacate. So if there are fees or charges that the tenant has accrued for whatever reason, we have to ensure that those fees and charges are in fact defined as additional rent. Now, in our lease agreement, we have provisions that state that basically all fees or charges are owed as additional rent. So our lease covers basically any charge that the tenant owes, and we can demand that as rent in that notice. But if we inherit a lease from another property management company or a landlord who had one in place when we took over management, we have to make sure that we look at that lease agreement and ensure that it's defined as rent. And this also goes to when we set up the property management software, property profile and the tenant profile, that we are including fees and charges properly. And if they're not defined as additional rent, that we do not include those in the notice. As a general rule, it's actually a better practice to be conservative as it relates to additional rent rather than just throwing in everything that we possibly can in the notice. We would be more conservative and just include things that are absolutely certain to be rent and be certain that the 3-day notice is going to be legally sufficient to succeed on the eviction. If you ever have any questions about whether an item is additional rent or not, you need to consult with your broker or your supervising manager and go over that information to ensure that the notice is correct. And then within the notice itself, we have the section of where you put in the rent items. Now, there's a couple of approaches here when doing this. One is you can itemize it the way we have in this diagram or this sample form to actually identify each individual line item and identify that in this column section. The other approach is simply to put in a lump sum amount in the form, and either approach could work. It actually depends on the judge. There are some judges that if there's a lump sum and the tenant cannot identify really what the accounting is or understand what they're actually behind on, what rent amounts, some judges look at this differently. In our area of Florida that we have properties, Escambia County, Santa Rosa County, it's generally sufficient just to put in the lump sum amount rather than having to identify each individual item as an accounting method. So that's typically what we will do. Another approach is we can print out the lease ledger and just simply attach it to the notice, and we can reference the lease ledger within the notice itself so that the tenant can see what the accounting is. Again, on late fees, they have to be defined as additional rent. So ensure that the lease agreement does in fact define late fees and other charges as well as additional rent. And then within the notice itself, we have a total owed. As I just mentioned, we can either itemize the individual monies owed, or we can include the lump sum total in the demand. In our area in Florida at the moment, in Escambia County and Santa Rosa counties, the lump sum is sufficient. If we get into different counties where this is not the case, then we need to essentially do what we know the judges expect to be done, and to avoid any sort of issues as it relates to the legal sufficiency of the notice. Another issue arises that in the notice itself, you can demand that the tenant pay in a specific manner or location. For an example, delivering the payment directly to the office, as opposed to another method that the tenant may be used to paying. And so the real world example here is with our tenants, by and large, they pay rent through the online portal. And so, but if our lease agreement doesn't address how they're to make the payment or doesn't require them to pay in a certain way, we could require that they pay in a specific manner, such as delivering the payment to our office. As a general rule, we don't add any specific requirements as to how they pay, because we expect them to pay through the online portal, which is how we require them to do so in the lease agreement. So as a rule, we're really not going to change the manner in which we require them to pay the rent. But if there ever is a situation where, for an example, we turned off the online payment feature for whatever reason, then we would need to notify them that they are to deliver the payment to our office. Another thing to keep in mind here is that we have to ensure that there's no conflicting information within the notice itself. We can give examples of this, but basically, you don't want to give information within the notice that could be conflicting with each other. Government subsidy tenants, there are specific rules as it relates to them. We don't, as of right now, as of the date of this video, really have any government subsidy tenants. But if we did, we would have to follow the specific rules as it relates to notices to pay to those tenants. But you cannot demand in those notices the money that the government is responsible to pay for. Rather, it's only what the tenant is responsible to pay for, their portion of rent liability. You can review the how to calculate notice periods in that particular video, but this is a section here if you want to pause for a moment and just read some of the highlights of calculating the notice period to familiarize yourself with how the rules work. Another issue to keep in mind is if we inherit a lease from another property management company or landlord, and that lease requires more than 3 days notice to pay or vacate, then we have to comply with the lease agreement. In other words, it's a minimum of 3 days, but it could be more if the lease agreement requires that. So we just have to ensure that if we have another lease agreement in place that's not ours, we need to ensure that it doesn't require more than 3 days notice. But our lease agreement just simply follows the statutory requirement. Same thing as it relates to how many notices are supposed to be given. You do run into situations where it's another lease, it's not our lease, and for whatever reason in that lease, it required the landlord to deliver more than one notice to the tenant before they can file an eviction. For an example, the owner has to deliver a 3-day notice to pay, and then after that, deliver another notice telling the tenant that they're going to terminate before they can actually file the eviction. Our lease doesn't have that requirement, so we're just simply looking at delivering the 3-day notice to pay or vacate. Again, there are additional rules for HUD tenants where you have to give the public authority notice of the notice to pay or vacate. Again, we don't, as of right now, don't have HUD tenants, but if we did, we'd have to follow those additional rules. And then within the notice, we have to sign the landlord signature line towards the bottom. We would actually have our specific information, our name at the landlord line, the phone number, and the address. Again, reiterating, stating where the tenant pays rent. If for whatever reason we needed to demand that the tenant pay us at our office rather than the online payment feature, we would have to state that specifically in the notice. Another important rule is never to demand anything other than payment of rent. You have seen some situations in the past where a landlord thinks that they can demand things like the security deposit that hasn't been paid yet. You cannot do that. You cannot include any deposit or anything that's just not defined as rent. Bottom line, it has to be a rent payment owed as opposed to other types of payment. For an example, security deposit. Now, we should not be in a situation where the tenant hasn't paid the security deposit because that's required to be paid before they actually move into the property. But just as a rule, you just need to understand that we cannot make a demand for deposits in a 3-day notice to pay or vacate. And then we have the certificate of service section of the notice that has to be completed. So when we deliver the notice, typically it's by email. we state that we delivered that on the specific date, and we would check the box for email, and then we would include all of the tenant's emails in this section here. That means every tenant's email on file, we would put that in this section and actually deliver it to those email addresses, and then sign as the server. We want to make sure, of course, that the date is correct, that we serve the notice, because this will dictate how we calculate the pay or vacate date. So if we deliver the notice on a specific date, we have to calculate the 3-day notice period based on the date that we deliver. So you can go to the calculating notice periods video for more information and training on that. But if we put the date of delivery in the certificate of notice as a particular date, it's got to be that date that we deliver the notice, and we have to calculate the notice period based on the date of delivery. Again, the server who serves the notice has to then sign that section. Now, during the notice period, we go over this in the tenant default video, but just highlights here, you can pause and just look at some of this information about during the notice period. So effectively, we can require the tenant to pay the full amount of rent during the 3-day notice period. And when a tenant attempts to pay partial rent, we can reject that payment and send it back to the tenant, or we can accept it. And if we accept that partial payment, we have to then serve a new 3-day notice to pay. So as it relates to whether or not to accept or reject, go back to the tenant default video and get training on that. But we look at the tenant's history and determine, is this someone that we want to evict, and we know we want to evict, they've been a problem, we really just need to get them out of the property. In those situations, it's going to be probably the choice that we reject those partial payment, and if they in fact try to pay, we send it back to them with the form email that we have at Lead Simple, stating that we reject the payment, and we send it back or credit it back to their account. If in fact we decide that we're going to accept it, again, we serve a new 3-day notice with a new amount. Now, after the 3-day notice period, if they have not paid rent in full and we have not accepted any partial payment, we now have a right to evict the tenant, and we can proceed in that regard. We will then notify the owner of the situation and recommend a course of action of eviction, and once that's approved to go forward, we will send the matter over to our attorney for filing the eviction. Now, if in fact the tenant comes to us after the 3-day notice period and attempts to pay or says they want to pay, we then can work out a resolution if we want to with that tenant. Again, going back to tenant history, do we want to keep this person as a tenant, or do we want to evict them? Obviously, if we want to evict them, we're not going to accept rent unless we can reach an agreement that they actually agree to leave, even with paying back rent owed. So that really, that kind of an agreement, of course, needs to be drafted by our attorney as a settlement agreement, and we can effectively try to get rent and end the tenancy with this tenant. But if it's a tenant that we would like to continue working with, then basically we're going to work with that tenant as far as getting that payment and avoiding the eviction. This is just some tidbit of information about evictions for various reasons. There's basically a sort of a hierarchy of evictions, ones that are easier to handle and ones that are harder to handle. So 3-day notice to pay or vacate are on the scale simpler evictions, but you can see here in this list, the easiest one is terminating month to month, and then a holdover tenant, that is someone whose lease has ended and they don't have permission to be there. That's also an easier eviction to deal with. And then 3-day notice to pays are similar in nature. And then as you go down into the 7-day notice to cure and then the non-curable violations, those are a little bit more fact intensive, and so those are a little bit less ideal as far as just the simplicity of the eviction. But if we ever have a situation where we have a tenant who's on a month to month and they're having a problem with paying rent, we can approach it from both perspectives. We can terminate the month-to-month tenancy and at the same time, deliver the 3-day notice to pay or vacate. And if they fail to comply with either or both of those notices, we can file an eviction based on both of those notices. So the proper notice to pay or vacate diagram, if you want to just pause this for a moment and just familiarize yourself, this is just essentially a picture of what we're looking at in the 3-day notice itself.